the number of personal exemptions that are available to our taxpayers here in Pinellas County and throughout Florida, and give a refresher on homestead and portability as well. On behalf of Mike Twitty, your property appraiser, I'm Kevin McKeon, the Deputy of Assessment Administration. I'm joined today by Amy Lesk, who's our exemption specialist, who will walk you through the personal exemptions. I would just like to remind everyone, if you have a question, please put it in chat. We have quite a few folks online. You are all muted, and we will address the question as it comes through the chat. So again, thank you so much for joining us today, and we'll get started. Starting with personal exemptions. Amy?
In 2023, a new law passed changing these exemptions, the widow, widower, disability, and blind exemption amount from reducing the assessed value from $500 to $5,000, which increased the yearly savings from approximately $10 a year to $100. If you were already receiving any of these exemptions, this change was automatically made for you. Homestead is not required to get one of these exemptions, but you must be a Florida resident. There are also exemptions for the totally and permanently disabled persons that meet requirements of paraplegic, hemiplegic, totally and permanently disabled, must use a wheelchair for mobility, or legally blind. You must meet the 2022 total gross household income of less than $34,282 and provide your income backup. You would also need to apply 2 Florida license physician letters stating your qualifying disability. And then yearly, you would renew this and provide your income backup. Low-income senior exemption is available to those who have a homestead and are at least 65 years old as of January 1st of 2023. This exemption is income-based. If the 2022 gross adjusted household income is $35,167 or less, you would qualify. This would reduce the taxes of your taxing district.
We have a question from a guest. Can someone with permanent SSD for schizoaffective as total disability, if the Social Security Administration claims that you are totally disabled, you would be entitled to the $5,000 exemption. But for a total and permanent, you would need 2 Florida physicians to say that to be qualified and also be below the income.
This is a quick list of the cities that participate in the low-income senior. It shows the approximate savings for each taxing district. For example, if you live in Dunedin, you would get an additional 500 or 50,000, I'm sorry, 50,000 off the city millage. That would be up to $207 annually off your taxes.
Okay, another question came through. Do you have to apply annually or one time? All of our applications are only required on a one-time basis. Back to the total and permanent income disability, we have to verify your income every year to make sure it's below that threshold. And occasionally we will do an audit on the senior income as well to make sure that you have not gone above that threshold. But later on, we'll show you a renewal notice that we send you, and you can also let us know if you don't meet that threshold anymore. But most, if not all, applications are only one time, and then with the exception of, again, the income, having to provide that to us annually.
For the low-income senior long-term resident exemption, there are 3 municipalities in our county that participate. That is St. Petersburg, North Reddington Beach, and Safety Harbor. If you qualify for this exemption and you've been receiving the homestead for 25 years or more, and your just value is less than 250,000, you are exempted from your municipality taxes based on the first year of your initial application for this exemption.
Yeah, so it's, for instance, in St. Petersburg, this was instituted a couple years ago. The millage rate in St. Petersburg is about 1/3 of your total taxes. This is a very valuable exemption. Again, it has to be the same home that you've lived in for 25 years or more and had homestead on it and qualify for the low income senior exemption. So if you already qualify for the low income senior exemption and you live in one of these municipalities and you've been there since, I believe the year is 99 was the first year of homestead, 2023 would be your first year that you would be eligible. So please contact our office if you believe you're eligible, and we can get you to apply and get that the full city millage exempted from taxes.
For exemptions, dates are very important. You must own, occupy, and be a permanent resident as of January 1 and make your application by March 1st of that year. The VA disabilities must have an effective date as of January 1 or prior. For the senior exemptions, you must be 65 as of January 1 of 2023 or prior and submit your supporting income documents by June 1st. There are exemptions for disabled veterans and first responders. If you're a veteran that's service connected 10% or greater, you're entitled to a $5,000 exemption off of the assessed value, which is approximately $100 savings a year. If you're a total and permanent service connected veteran, you're entitled to 100% exemption from the ad valorem taxes. Veterans age 65 and older with a combat disability, your exemption would, your percentage of your VA would deduct from your taxable value. So if you're 70% disabled, you get 70% off of your taxable value. Veterans confined to a wheelchair requiring special adaptive housing makes you also exempt from their 100% exempt from the ad valorem taxes. Florida first responders, total and permanent disability that occurred in the line of duty are exempt from the non-ad valorem taxes. And all of these exemptions do pass on to your surviving spouse.
Yeah, we wanted to mention under certain conditions, if the surviving spouse remains in the marital home in each one of these cases, the exemptions would be maintained forever. If the surviving spouse remarries, they would all go away. If the surviving spouse moves to another home within the state of Florida, they would only be able to take with them the amount of the exemption after qualifying for homestead that existed on the home that was sold, the marital home that was sold.
For these veteran exemptions, there's different documents you can provide for proof. That would be your summary of benefits, your rating decision letter that shows your disability with the effective date and the percentages, your DD 214, which is your honorable discharge papers, the death certificate of the veteran if you're applying for some of the surviving spouse ones. If you aren't able to get any of these documents, you can contact the Pinellas County Veteran Service Office and they'll help you provide that proof to us. Their phone number is 727-464-8460.
They are very helpful to our office in helping the veteran get through the VA and getting all this information. So if you need any help, please contact them. They're a great service, and we'll help you. We'll help you get through everything that's required to get you qualified for our exemption.
Deployed service members.
So I'm sorry. Quick question. Let's go back to that. Do we need all three forms of proof? Was first question, and where do we submit the paperwork?
You don't necessarily need all forms. The summary benefit does cover for the veteran rated 10% or greater, and sometimes it will do for the veteran rated total and permanent. Usually that's listed on your summary benefits that they send out to all veterans every December. The rating decision letter, you would need that for the combat disability because we have to see what disability you're currently receiving in order to get that combat disability. A lot of those disabilities are like Agent Orange related, ischemic heart disease, prostate cancer, diabetes type 2. So we would have to see that laid out in your rating decision letter, that verbiage on there. And the DD 214 does help with the combat one as well. It just places where you are. We have authorization to reach out to Veteran Services with Pinellas County. We submit the documents over there to them if we don't have all the paperwork, and it kind of helps them piece it together, and then they would call you if they needed additional information. So they are a huge asset to us and you when we're trying to do that combat disability and some of the other ones as well.
And where do we submit the paperwork? You can submit it once you have the paperwork. You need to come in and apply for these exemptions. And you just bring the paperwork with you. We will make a copy of it so we have it for our files. And, and one other thing I want to point out, and Amy, could you just talk about if the veteran is expecting to become 100%, they're not yet 100%, but expecting maybe in a year or two to be rated 100%, what our procedures are and what we can do when in fact that does come through.
If you have any claims with the VA that are pending or you're gonna submit a claim, the VA isn't always quick to make the decision. Sometimes it can be a lengthy process. So always apply for that exemption with our office so we have your application on file. Once the VA approves your rating and gives you a rating decision letter, an award letter, any of that proof, and say it takes a year, we will come back and fix that first year you applied up to 4 years. We can go back up to 4 years based on that first year of application. So if it takes them 2 years and you applied in 2023, they didn't make a decision to 2025, we can fix 2023 forward and do a tax correction, but we must have that veteran application on file in order to do any corrections.
And that's if that ratings decision letter goes back to 2022. Right. To be effective in 23, we can then do tax correction. So it's important when you come in, go ahead and check the box for total and permanent. If you expect you may get it soon, then we know you've applied, and if in fact it's retroactive back to a certain date, we can then do a correction for your taxes, as Amy said, up to 4 years. So 315 Court Street, second floor, submit the paperwork. We have 4 addresses throughout Pinellas County. We have one in North County on US 19, just south of Curlew Road. One in Mid County on Starkey Road, just south of Ulmerton, co-located with the tax collector. And also one at 2500 34th Street North in St. Petersburg. That's a brand new building, again, co-located with the tax collector. And we are upstairs on the second floor. No appointment is necessary in any of our offices. So we're open 8 to 5 Monday through Friday. Come to the office that's most convenient for you and we'll take care of it.
Deployed service members also have an exemption. You must be receiving the homestead exemption in order to qualify for the additional deployed. You have to be deployed to a qualifying operation designated by the Florida legislature. That list comes out every year. They will update it. Sometimes they'll take off operations and add new ones. So we get a new list every year. This exemption will reduce your taxes by the number of days you're deployed outside the U.S. And this exemption is available to active duty military or reserves, including Coast Guard and Florida National Guard.
Okay, I want to address this transfer tax exemption for veterans. This took effect in July 2020 for purchases of new homes after January 1 of 2021. In the past, if you had a total permanent exemption and you sold your home with every exemption in the state of Florida, the buyer inherits that exemption of your home through the end of the current calendar year. So let's say you sold in June, you paid no taxes, that buyer would pay no taxes for the rest of that year. And let's say you bought a home and in the same year, you again would have inherited the exemption of the people you bought it from to the end of the year. So you would pay taxes for the amount of time you owned that home. The governor signed into law So if you now sell a home with total and permanent exemption on it and buy one in the same year with total and permanent exemption, you have to pay the taxes in the new home that exists through the end of December. However, now with this new law, for the number of days that you own that home, the new home, we will then process a refund for the days that you owned it. In other words, you get a credit from the seller for the days that they owned it. You pay the taxes. We'll give you a credit for the days that you owned it. So in effect, you pay no taxes on the new purchase either. This sounds confusing, but if you are a T&P veteran and you sell a home in 1 year and buy another one in the same year, be sure to contact our office and we can walk you through the process of getting that refund. You do have to pay the taxes, but then you'll get a refund probably sometime in March or April of the following year for the taxes that you did pay. Let's see. We have a question. If I was bought out of my former homesteaded house by my ex as part of my recent divorce, can I still port my homestead exemption that I had at my former address to my new home, or does that go with him? That's a very good question. I guess a lot of questions that come to our office, our answer is that depends. That sometimes in the divorce decree, it states who gets the deferred amount on the home. Most times it doesn't. You can agree as ex-husband and wife to fill out a form, and it's, which form is it, Amy? The 501
Designation, yeah.
501T TS, that where you split your portion of the portability. So if you have any question with regard to that, please call our office because there's many ways you can go with it. And it is a very valuable asset, we understand, and it should be considered. The state says you have to consider it prior to divorce, but if you agree after the divorce, so and so gets this percent, so and so gets the other percent, we can make that happen in the new home that you happen to buy. Good question. Thank you. Okay, quickly we'll go through a review of homestead exemption. We have done this in other presentations, but it's good to have a refresher. A lot of you out there may be new buyers who happen to buy in 22 or in 23, since we're already through in February. So one thing that's important to understand, every time you buy a home, you have to apply for the homestead exemption. Unfortunately, a lot of people think it automatically transfers. It does not. You have to come in and apply for that exemption, even if you had a previous exemption on another home in Florida. A little bit of the history of the homestead exemption. Back in 1934, there was actually a $5,000 exemption. And then in 1980 was the first $25,000 exemption that came on. And then in 92 to 95, there was an amendment called the Save Our Homes Amendment, and I'll get into that in later slides. That is actually the most valuable part of having a homestead exemption in the state of Florida, if you remain in your home for a number of years. And then in 2008, the second 25,000 exemption came in, and also the 10% non-homestead cap, and I'll explain that a little later. So the two homestead exemptions, the first 25 and the second 25, provides a 50,000 reduction in the property's assessed value to come up with taxable value. However, they are tiered. The first 25 in blue is totally exempt from taxes. Now, this is assessed value on your property. The second 25, there is no exemption. And then the value from 50 to 75,000 is exempt from taxes, but is not exempt from school millage. When they instituted this in 2008, they didn't want to reduce the school taxes collected by the amount of the impact of this second exemption. So it's on every other millage rate, but for schools, that second 25,000. And then above that, there is no exemption unless obviously you have personal exemptions that we discussed in the first section of this presentation. Now, depending on where you live, the millage rates are quite different throughout Pinellas County. They can be as high as 6 to 7 mills in some jurisdictions, and as low as 2 mills in others, or even lower. So the first and second combined homestead exemption is worth about $50 to $500 to $1,000 off your property taxes. And the Save Our Homes cap, and back with the previous slide where I mentioned the Save Our Homes amendment back in 92 to 95, that was instituted because people were being priced out of their homes. That was a time in Florida where real estate was going up exponentially, and this Save Our Homes cap was instituted to protect the homesteaded homeowner. Meaning, once you qualify for homestead, let's say your first year of qualifying for homestead was 2022. At that point, you are a new buyer. Your assessed value equals your market value if you're a first-time homesteader in Florida. Every year thereafter, that market value could change, but the assessed value can only go up by a maximum of 3%. It's 3% or a consumer price index, whichever is lower. So basically, it in effect is another additional exemption. And we've had longtime homesteaders here in Florida, and you may have some in your neighborhood who are paying, if you're a new buyer, they're paying significantly less taxes than you are because they bought a long time ago. They've been subject to this Save Our Homes cap, and you were a recent buyer. Again, qualifying homestead criteria. You must own and occupy as of January 1 to qualify for homestead. So if you're a recent purchaser in 2023, let's say you bought February 1, your first year you could qualify for homestead is 2024. Beginning March 2nd and afterwards, our website will automatically change to 2024 applications. We'll also accept late file 2023s with an extenuating circumstance form, but there's really is no need to apply for 2024 if you're a new buyer this year until after March 1, and you see that the deed has on our website has you as the owner. You must be a permanent Florida resident. The qualifying criteria for a permanent Florida resident is you must have a Florida driver's license. You must have a Florida auto tag if you have an auto down here. And you must not have any other residency-based exemptions in the United States. If you own another home in another state and it has an exemption on it, you will not qualify for homestead here in Florida. You can remove that exemption if you so choose, and then we can qualify you, but you can't have two in the United States. Corporate entities are not entitled to homestead. LLCs do not qualify. So be careful when changing your deed for insurance purposes or for legal reasons into an LLC, you will lose your homestead. There are other ways to protect yourself other than transferring it to an LLC. What do I do if my address listed for my homestead exemption is incorrect? Please contact our office and we can correct it. It could possibly be that it was an error on the deed, and that's how we processed it. We keep the site address as one address, and we keep a mailing address in the other. Typically, if you're homesteaded, the mailing address is the same as the site address. So that way you get all your mail where you live. But hopefully I've answered that question. Please call our office and we can take care of it. It could be a typographical error in our system that we can take care of quickly. Area code 727-464-3207. Excuse me. I am a longtime homeowner who has owned since '09. However, I just became a permanent Florida resident in 2022. How does that impact my assessment value? Unfortunately, yes, you did own that home since 2009. It was, I assume, was not homesteaded because you were not a permanent Florida resident. State law requires us that if somebody first applies for homestead, no matter how long they've owned the home, you were subject to the 10% cap as a non-homesteader. The year you first apply for homestead probably will be 2023. Your property goes to market value. So market will then equal assessed at that point, and then you begin your homestead and save our homes cap starting in 2024. That was a with the rise in market value in 2022 over 2021, that caused a lot of angst among people who had vacation homes down here. They decided to make Florida their permanent residency, and unfortunately, state law requires us to move that to market value. So in a lot of cases, some of those people were better off not having homestead and continuing on with the Save Our Homes cap. Excuse me, the 10% cap on a non-homesteaded property, because their taxes would be less under that. Again, if you have any questions with regard to that, and if we can provide you an estimate both ways, and a lot of people did. They forego their homestead because there was a significant difference that caused the assessed value to go to market. What if they had been a resident and moved from a homesteaded property? Good question. We will get into that when we talk about portability. That's coming up in the presentation. We bought, closed in September 22. When will I know my market value? Well, each January 1, especially following a purchase, that home gets revalued to market. Now, we typically finish our valuation. We have 430 some odd thousand parcels of real estate that we have to value every January 1. So you will know specifically a good, very solid estimate of your value on June 1. That's when we have to provide estimates to the taxing authorities. So our appraisers are pretty much done with their values. And so I would encourage you to call us on and around that time to find out what that market value is. For those of you who have homestead, hopefully this week you receive this notice. We as a courtesy here in our office, it's not required by law, but we as a courtesy mail out to all homesteaded properties a receipt for their tax exemption renewal. Once again, once you apply for homestead, you never have to apply again. It automatically continues as long as your status does not change. So this notice is twofold. One, it lets you know the exemptions that you have on the property. For instance, this particular homeowner had a homestead exemption, a widow exemption, and a veteran surviving spouse exemption. Now, this also gives you the opportunity to let us know if anything has changed in your world. Are you, please remove my homestead. I no longer own it or occupy it. If you have sold it, we will eventually get notification that you've sold it. And in some cases, those who have sold their property still got this notice because we didn't get the deed till after we processed this data file to go to our printer. If one of the owners is deceased, This gives you the opportunity to let us know so we can then get the widow or widower exemption in the year or future years. If you are renting part of your property, let's say you have a home and a garage apartment, it is your obligation to let us know, because any rental would cause that percentage of the property to go to non-homestead. You still would retain your homestead. And then there's the senior exemption. Let's say you didn't even know about the senior, or your adjusted gross income just fell in 2022 from prior years. You can check this box, say you're 65, provide us the income information, sign the bottom, and that in effect is your application for seniors, and we can get that process. Marital status is very important. As stated before, a married couple can only have one homestead. It's not unusual to have someone get married and both spouses have homestead exemption. One of them needs to be removed at your choice the January 1 after you are married. If not, that creates a dual exemption, and if we find out about it at a later date, you are subject to penalties and interest that are very high. That's why we send this out. Let us know. We can take care of it and go from there to avoid any penalties and interest for a dual exemption. The second notice we sent out on an annual basis, you will receive in late August. This is a notice of proposed property taxes. This lets you know what your property taxes, in this case for 2022, and the new one coming up in August will be for 2023, what your estimate of property taxes will be. This blue box is extremely important. This is the current year, okay? This is the prior year. If you bought, let's say in 2021, you will see in 2022, in most cases, unless you have portability, and we'll get to that, market equal assessed. And then if you have no homestead, if you have not filed, assessed equal taxable. In this particular case, this resident had a homestead exemption and another exemption on it. But if these two equal and you forgot to file, you will still have time, about 25 days. After that, there's nothing we can do for the homestead for that particular year. A very, very important document. Please read it. Please call us if you have any questions with regard to it. Again, highlight the blue box. This particular one had a homestead exemption. This was probably continued on. This property did not sell. Last year, the Save Our Homes cap was 3%, so it went from 221 to 228. You can see the market went up $100,000. Assessed only went up by 7. So you got a $93,000 exemption right there. That under the laws of the state of Florida. So your taxable value only went up by about $7,000 when you had a market value increase of over 100. Again, a very valuable exemption. If you want to see your trim notice from last year or any other year, you can download the trim notice right from we usually post these before they're mailed. In sometime in mid-August, but you would receive it in late August. Exemption portability only for Florida residents. Yes, you cannot port from another state. It's only Florida residents who had a previous homestead, and I'll get into that. Let's see if we have any other. Low income senior, is it a combination of both spouses? Yes, it is total household income. Only one of you has to be over 65, but the total income of both spouses has to be included in your total household income. And dual ownership, daughter and mother. Mother is a senior. Do we get the senior exemption? Yes, if mother is the homesteader. If mother is the homesteader, mother would get the senior exemption, again, subject to the total household income of $35,167. Can you explain the Lady Bird deed and how it relates to homestead exemption? Deeds and trusts can qualify for homestead. And for the most part, the homesteader must be the trustee of the trust. And Lady Bird deed, you can have a deed and have someone else as the remainder, as long as you are the owner of the home until you pass. You can qualify for and continue to qualify for homestead. But be very careful when you're filing a new deed. There are many, many, many missteps that are made with regard to deeds that can take away your homestead and your Save Our Homes cap. Man, all these wonderful questions. I love it. Why is homestead exemption capped? Well, the homestead exemption is 50,000 for now. I believe 2 or 3 years ago there was a ballot initiative during the 2020 election that would have added a third exemption. It was either 2020 or 2018 of 25,000. We go by state law. Your state legislature and state senate are the ones who pass the laws. So I agree. A $50,000 exemption that existed back in 2008 isn't worth something that that in 2023 with the cost of things going up. But that's why that Save Our Homes cap is there. So once you have it, if your value continues to go up, you're limited to the increase. Let's see. Can one rescind their homestead request approval before it starts? Absolutely, you can. If you call our office and you've already applied, we've already granted your homestead, but you figured out that, oh, I didn't want to homestead this property or another, or I'm better off having the 10% cap, just call us up. We'll ask you to email us and ask you to send us an email to remove my exemption. We could do that very easily. Okay, Save Our Homes. This gets into Save Our Homes cap and how it works. Again, it started in 1992. It limits the assessed value increases. Catch up with the questions here, right? Let's see. On capped question, I was referring the mail that shows capped percentage. Your example was 100% minus 51%. That may be a case where only part of your home is homesteaded because you are renting out a portion. Sometimes we have cases where the deed is tenants in common, where one tenant lives there and the other does not, and they are only entitled to a 50% homestead. Now, depending on the value, they could still get the $50,000 exemption. But what that means is if half the property is non-homesteaded and the other half is homesteaded. So in effect, half would be subject to the 3% cap, the other is subject to the 10% cap. If you have an issue with regard to the percentage homestead that we have on your property, please give us a call. And we'd be happy to walk you through that or see if there's a way that, that it should be a different percentage and help you through that. Okay. My wife and I are both listed on the tax exemption renewal form. Will this cause a dual exemption? Not at all. Again, under Florida law, a married couple both are required to file for homestead because a married couple is only entitled to one exemption. So we need the information for both of you. Whether both of you are on the deed or not, we have to have the spouse information. If one spouse is on the deed, the other is not, we still need the spouse information, because what that helps us do too, if God forbid something happens to one of you, that spouse would inherit the homestead exemption going forward because you were a married couple. So Save Our Homes. Again, as I stated, designed to protect Florida residents being taxed out of their properties. The difference between just and assessed is known as the Save Our Homes benefit. Let me get back to here. So this gives you an idea of the CPI. Until the last 2 years, and as all of us know, prices have gone through the roof. CPI has been quite high in 22 and 23 at 7 and 6.5, but it's the lower of 3% or CPI. So you look at all those years between, let's say 2013 to 2021, you see that CPI was very, very low. So that limited the increase of your assessed value, and in some cases to less than 1% in 2015 and 2016. So again, a very valuable asset. Non-homestead cap, again, 10% a year. In all cases, however, assessed value, whether it's capped at 3% or lower or 10%, can never exceed market value. And we'll go into some examples there. And then again, all caps reset on January 1 after a transfer of the property. Transfer meaning you transferred the deed to a family member who no longer had homestead. You sold the property and now it's owned by somebody else, or you filed for homestead for the first time, even though you've owned it for quite some time. That is, in effect, included as a transfer. So this just gives you a quick example. We have market value rising at 5% to save our homes cap at the maximum of 3. So the following year after you have qualified for homestead, you have a $6,000 Save Our Homes benefit. And here's the year after purchase, assessed equal market if you don't have portability, which we'll get into. And then every year this builds, and as you can see, by year 7, you built up about a $44,000 gap between your assessed and market value. I will tell you, since 2012, market values have risen over 10% compounded from 2012 to 2022 in Pinellas County. So that gap between market and assessed is very large on many, many properties here in Pinellas. And you do not pay taxes on that gap. So your benefit of $43,000 and change, you are not paying taxes on that. You are paying taxes on the assessed value minus your exemptions. But that only applies if you have homestead. So here's a perfect example of, let's say you sell the home. The year after purchase, the new owner, who was not a previous Florida resident, applies their homestead exemption. Their taxes go from $6,100 to $9,000. Again, by state law, everything gets reassessed. Example of 2 identical homes in the same neighborhood. One was bought and been homesteaded since 1993. So she or he or they qualify for the 25-year homestead exempt. St. Petersburg, these homes happen to be in St. Petersburg. The one on the left bought in 2018. You see the disparity in taxes, $4,300 versus little less than $700. Again, the benefit of being a longtime homeowner, and the unfortunate benefit of being a new buyer creates that tax disparity. I'm not saying it's fair, but it's the state law that we have to apply. And then the 10% cap, which was approved for 10 years in 2008, but in 2018 it was reaffirmed, so it stays forever. It applies to all properties that do not have a homestead exemption. That's commercial property, second homes, rental properties, vacation homes. Now, the one thing that's important to understand, that 10% cap does not apply to school taxes. Once again, and school millage rates can be about 1/3 of your taxes. So if your market value, let's say, exceeds your assessed value under the 10% cap, that difference you still have to pay school taxes on. You don't get a 10% cap on school taxes. It does not have a cap. Oh, my goodness, all these people getting ahead of me. This is awesome. Last question, last question that came in. What happens if a home is damaged in fire and uninhabitable? Can I still apply for a homestead? We have that example coming up for you. Get back to the screen. So this is the ups and downs of what happens sometimes in the marketplace. The yellow line is the assessed value. The blue line is the market value. You're not paying on that difference. If you are homesteaded or non-homesteaded for that matter, and non-homesteaded except the school taxes. But we've had ups and downs like that before. We had a big rise in market value between 01 to 07, and then the market crashed and it went back down. But again, once that yellow line hits the blue line, it can't go above market. They ride down together, but they don't ride up together if you are homesteaded or even the 10% cap. So it goes back the other way where you're not paying taxes on that gap. So you've got a declining market, you've got a increasing market, year 1 to year little over year 3, and then year 6 to year 8, it starts increasing. The other time it declined, where they both meet. Does the school taxes go above the 3% cap on the homestead? They do not. Only on non-homesteaded property. Good question. But you are paying school taxes, as I mentioned, on that second $25,000 of homestead exemption, which amounts to around $150 more in taxes for everybody. Portability. So this is where we get into if you were a previous homesteader in Florida. You've been a long-time homesteader, let's say in Pinellas County. You decide to downsize or upsize depending on your preference. Whatever you have in the January 1 in the year you sold, you get to take with you to the next home, but you have to homestead that home. It doesn't automatically port over to your new home. You do have to apply, and you have 3 tax years from January 1 to reapply for homestead. So if you're getting something built that takes more than a year or 2, you still can qualify for the portability once you file for homestead. So the maximum amount you can port to a new home is $500,000. So if your new just value of the home that you purchased is greater than the previous just value. Now, the new just value would be the January 1 after you purchased. The previous just value would be the January 1 in the year you sold. You compare those two numbers. If new is greater than previous, you get the entire amount of port, subject to a $500,000 cap. If in that same instance, if the new is less than previous, you get a prorated portion of that. So if, let's say new is 80% of previous, you get 80% of the previous Save Our Homes benefit applied to the new home. Again, limited by the 500K. So you apply the percentage to the total port, because there are some people who downside. Let's say they had $1 million in difference, but they downsize so much that it's 40%. They still get 400,000, but they can't get more than 500. We have a tax estimator on our website that'll do this for you. You can put in the home you're buying and the home you're selling, and we can estimate the taxes in the year after purchase for you. And we'd be happy to do that for you if you give us a call as well. So the previous law only allowed 2 years. Actually, by the end of year 2, January 1 the next year, you had to you had to establish homestead by the end of that second year. So if you sold right here, you really only had 1 year in order to, and that caused a lot of angst because of new construction, delays, et cetera, et cetera. But legislation championed by Mr. Twitty and this office got that increased to a third year. So now if you sell here, you really have 2 full years to reestablish homestead and take advantage of your portability from this point forward. So if you sold in 2022, the 3 January ones that count are January 1, 22, the year you sold, 23 and 24. You must reestablish homestead by January 1, 25, or move in and occupy by January 1, 25. So that's the three window years. See. How often do you assess the property for fair market value? Every January 1. We are required by law to value properties every January 1. So that is the short answer. And if you buy a home, it will be reassessed. Most of the residential homes are valued on the sales approach. We know all the sales of properties that happen in every neighborhood. So most of that value is determined by the amount of sales and the sales prices of similar homes. Okay, common missteps. We talked a little bit about this. Deeds. Please be very careful if you want to change a deed, if you want to add your children to a deed, if you want to add anybody else to a deed, it can trigger a loss of a homestead exemption. We always recommend you consult an attorney to do this for you. Our office is more than happy. We have 2 attorneys in our office who are more than happy to look at the new deed before you file it to see if that would qualify. We cannot give legal advice. We often get questioned about legal advice, but we cannot give legal advice, but we'll be happy to review a deed to make sure that it doesn't cause a cap loss, either in the 10% cap or the homestead cap. Renting your homesteaded property, that's a no-no. The rule that we apply here under state law, if you rent for 30 days or more in 2 consecutive years, you will lose your homestead that second year. So let's say in 2022, you rented your property for 60 days, and in 2023, you rented your property for all of January. Well, that's 31 days. You've lost your homestead in 2023. So the onus is on the taxpayer to let us know that you're renting. In a lot of cases, we find out that you're renting from your neighbor because they don't like the noise. Let's say you're using Airbnb or VRBO. And if in fact you do not report that to us yourself, a self-reported incidence of rent removing the homestead does not cause penalties and interest. That is not self-reported does cause penalties and interest. And the state statutes are very penalizing. If we find that you have an undeserved homestead, not only do you pay the back taxes on if you wouldn't have the homestead, which means the cap is gone too if you develop one over the years, there is a 50% penalty on that amount and 15% interest annually. That can run into a lot of money. So please be careful. We're more than happy to answer questions if you're considering renting your home. But if you do, please let us know to avoid penalties. Again, here, changing the deed, adding a name, placing it in LLC, you could possibly lose your homestead and your homestead cap, causing your taxes to go significantly higher. All right, we are about 3 minutes away. I will answer. Let me get, okay, here we go. Damage due to calamity. This is addresses the question that we received earlier. Now, what happens if home is damaged by fire and uninhabitable? Can I still apply for homestead if a house under repair and I'm not claiming the homestead elsewhere? Let's say your house was totally destroyed by fire. Yes, you can keep your homestead on it. The home obviously will be removed. The value of the home will probably be removed. And until it is rebuilt, you will be taxed only on the land net. And then your exemption would still come off that, but you have um, a time frame that you have to do that within. As long as you get a permit to rebuild the home. This particular one is Hurricane Ian or Nicole. Again, we can, if your home was damaged by Ian or Nicole, we can process a refund for you for 2022 property taxes if it was uninhabitable for at least 30 days. And if it was, then we can look at the difference in the value during that period that it was uninhabitable and process a refund for you. Now the calamity example that we're getting into, let's say your home was totally destroyed by fire. We give you time to rebuild your home, get a permit, and you're only paying taxes on the land less your homestead exemption. And then once that home is complete, it gets added on the rolls the next January 1. So let's say that happened in 22. We've reduced your value January 1 of 23 to land less the exemption. And let's say it gets rebuilt by November of 23. That is then added to the rolls on 1/1/24. But if you rebuilt and it is less than 110% of the formerly damaged building, we will not add any value, no matter what the construction costs of the new home, over and above what we took off for the damaged home. That is a big it's a big benefit to a calamity. We don't wish that on anybody, but this law is very favorable to the citizen who has to rebuild their home. Now, if you go over 110%, only that portion related to the construction cost will be added over and above the cap. And anytime you do an addition to your home that adds square footage, there will be an add over and above the cap, the 3% or cap or CPI. Buyer and seller fact sheets. These are right on our website. If you're contemplating buying a home or selling a home, please access these from our website. It's a valuable tool for you to read. It tells you about what happens to your taxes, tax saving tips, et cetera, et cetera. And this is one of the best services that our county provides. It's provided at the clerk's office. I registered myself on there. Anytime anything is filed at the clerk's office in a name that is very close to yours, you'll get an alert. Unfortunately, there are instances of deed fraud throughout the United States and some here in Florida. But this is a free service. You go up to mypinellasclerk.org, and if anything gets filed in your name, whether it's a commencement of work, if you've got a permit, or if you paid off your mortgage, or if a mortgage was put on your property that you didn't know about, et cetera, this alerts you to it, and a lot of fraud can be avoided by signing up for this service. So we highly recommend you sign up for this. It's a great service. And then just a little pitch for the ways you can reach us and follow us: Facebook, YouTube. We have e-newsletters that are tailored for homeowners, real estate professionals, business owners. Please sign up for them, and also attend as many of our in-person or public education sessions. We welcome it. we want to educate you so you do all the right things and make sure you're get and are entitled to all the exemptions that are available in the state of Florida. Upcoming programs, first-time homeowners, another exemption section, real estate professionals, and then our new pcpao.gov website that's out there right now. Please go out there and try it. You can get to org or gov, but we recommend you drive gov and because we will be switching over to that in very shortly. Okay, well, once again, we are at 102. Not too bad. Let me see if I missed any questions here. Not married, but we bought the house under joint tenancy with rights of survivorship. Both of us applied for homestead. That's awesome. That is a very smart move because we have run into instances where, let's say, brother and sister, or mother daughter, or father son, joint tenancy, rights of survivorship. Only one applies for homestead, and when that person passes, your homestead and Save Our Home cap goes away. So very smart for both of you to apply. You only get one $50,000 exemption, but you are protected if something happens to one or the other of you. I moved from California, where I lived for 29 years, in my house. Not sure if it was homesteaded or not. How can I check? If you still own that home in California, you are probably subject to, I think it's Prop 8, where your assessed value was limited as far as increase, similar to the Save Our Homes cap here. So that is a residency-based exemption. So if you still own that property, that may preclude you from qualifying for homestead in Florida because it is a residency-based exemption. We can check for you for sure, but if it was subject to I'm not sure if it was Prop 8, Prop 13, something like that.
They do something, and California is one of the harder ones for us to check because they don't list owner names on their website. So a lot of times you'll have to call them and get proof that you've removed it, or just proof of the sale if you've sold it.
Excellent. Bought a new home in February last year. Are taxes paid in arrears? Yes, they are. All taxes due. You get a tax bill in November every year, and that is for that calendar year. So in effect, your taxes are in arrears. If you pay in November, you get a 4% discount off that tax bill. And that discount decreases monthly, December, January, February, by 1%. So if you pay in February, you get 1% off your taxes. You pay in March, you get 0%. You have to pay the full tax bill. After March, those taxes become delinquent. So in effect, you have till March to pay your taxes for the previous year. But if you have a mortgage, the mortgage company will pay your taxes in November and take advantage of the full 4% discount. The mortgage company, the tax collector knows you have a mortgage because that mortgage was filed with the county, and they know you have it. Can I rent partial home still living in the house? Will homestead be prorated? If this is a roommate situation, you have a 100% homestead. There is no issues with having a roommate. Our primary item is substantially all. So if you're only renting a portion of your house, more than likely you will not be jeopardizing your homestead. But we have some people who have created a room in the garage and put a little air conditioner and a little kitchenette in there, and I live in the garage while I rent it. Well, you're renting substantially all of your house. So you could, but you will lose your homestead in that case. If you receive an approval, is there another tax form that comes that needs to be filed? I guess I'm not sure what you mean by an approval. If you have a homestead approval, and it's brand new, you can go on our website and it will show that yes, you have homestead for 2023. But the first notice you will receive from our office with regard to that will be in August. That shows all the exemptions that you are approved for. One service we do provide for total and permanent exemptions, because in most cases those taxes go to zero. We send you a letter if you're approved for that exemption that you can give to your mortgage company. But if it's just a regular homestead exemption that you're approved for, we do not send you. The only evidence that we can provide you is what's on the website. And then in August, when the trim notice comes out, you will see that you have that exemption. Will these slides be available on your website? I believe they will be. I will leave that up to Kyle. Do you want to answer that in the chat, if you don't mind? Can you please leave the link of the place here, the website? So I think that is it. We thank you for all your questions. They were excellent questions. If you have any further questions specifically as it relates to your property, we are happy to answer them. Our main telephone number is 464-727-464-3207, right there at the bottom. Feel free to give us a call with any question you have. We'd be happy to answer it for you. And thank you all for joining us. We really appreciate it. And please join other sessions in the future. Thanks again. Bye.